Adam White is a senior fellow at the American Enterprise Institute, where he focuses on the Supreme Court and the administrative state. Concurrently, he co-directs the Antonin Scalia Law School's C. Boyden Gray Center for the Study of the Administrative State. Mr. White has practiced constitutional and administrative law, starting his legal career as a law clerk for Judge David B. Santel at the U.S. Court of Appeals for the D.C. Circuit. Mr. White has often been called to offer congressional testimony, and in 2018, the Senate Committee on the Judiciary called him to testify in the Brett Kavanaugh's Supreme Court confirmation hearings. In 2021, he served on the Presidential Commission on the Supreme Court of the United States, where he criticized efforts to restructure the Supreme Court. Mr. White's work has appeared in the Wall Street Journal, the New York Times, the Washington Post, National Affairs, and the Harvard Journal of Law and Public Policy, among other publications. Mr. White has a JD from Harvard Law School and a Bachelor of Business Administration from the University of Iowa. Please join me in welcoming Mr. Adam White.
If you can't hear me, just tell me to speak up. I'll do the best I can. It is a real pleasure to get to visit you today. I'm so glad to be here. And I will say, one person who's not glad that I'm here is my second daughter, Emma, because she's dying to tour Clemson. And when she heard I was coming here for work and she couldn't come along, she was a little bit ticked off. But I'll have only good things to say about her. I'm so glad, or about Clemson. I'm so glad to be here. You know, I was at lunch. I was in Greenville, giving a talk to a group of lawyers there on a very similar subject. Basically, I was hoping I could double dip and give the same talk twice. And the talk I gave to that room full of lawyers managed to bore them so much that I spent my afternoon thinking, what's the better way to approach this? Because the cases coming before the Supreme Court involving administrative agencies, I'll be honest, it's not always the most exciting stuff. I'm frankly kind of stunned that there are this many people in the room to hear a talk that has the word administrative in the title. I'm grateful you're here. Frankly, it's not usually the biggest attention-grabbing subject. But part of the reason of my talk is to explain why the issues coming before the Roberts Court right now involving administrative agencies are so important, and not just because they involve important areas of law. Just this past summer, the Supreme Court, one of its most important administrative cases involved the student loan forgiveness program. Obviously, an issue of immense consequence for everybody in this room and those of us who are now on the hook for their kids' tuition themselves. But from issues of the environment and energy, financial regulation, health, all sorts of regulatory policies are now coming to the Supreme Court, so those cases are immensely important. But they're even more important than that. The issues now coming to the Supreme Court go to the heart of constitutional government, and not just in obvious ways. And so it's a real pleasure to get to be here a few days before Constitution Day. I promise by the end of the talk, you'll see this talk is not a talk about administrative law. It's a talk about constitutional law and the ways in which those issues coming to the Supreme Court now are not just technical administrative law cases, but they are fundamentally cases about the Constitution and constitutional self-government. Like I said, sometimes the material tends to get a little sleepy. I usually insist that they serve coffee. I hear there'll be coffee outside afterwards, so I promise, just hold on. But in thinking through how to bring you into this topic, it occurred to me maybe the best way to ask, or to start, is by asking a question. This time of year is when a lot of people start thinking about politics, the political debates we're going to have for the next year and beyond. And so I'm going to ask a question about politics. We'll see if there's anybody that wants to jump in on this. And the question is this: who do you think has the best chances in the next elections? Who do you think has the best chances? Anybody? You, sir. Donald Trump. Anybody else? Who else? There are other candidates running, I'm told. Yes, sir. Sorry, Ramaswamy? Vivek Ramaswamy. Anybody else? Michelle Obama. Joe Biden. Thank you. Thank you all. All great guesses. And the interesting thing, for all of their disagreements about who's up and who's down, it's interesting that when we hear that question, we all think of presidential elections. I didn't say which presidential candidate has the best chance. I just said which candidate in the elections has the best chance. And it's so natural when we hear that question to think about presidential elections. I'm from Iowa. Like, it's all we do. We spend a year arguing about the upcoming caucuses, and then a year complaining about them, and then 2 years getting ready for the next Iowa caucuses. In our government today and in our politics today, when you ask about elections, we just naturally think first and foremost about presidential elections. It now comes so naturally, we take that for granted. And of course, presidential elections have always been important. Back to the very beginning, the first election of President Washington, as important as Congress is, I'd be fooling you if I said there was ever a moment in American history where congressional elections outpaced presidential elections for national public attention. Even in the moments when Congress was sort of preeminent relative to the president in terms of day-to-day power, those post-Civil War presidents with the beards, no one can remember which one is Garfield and which one is Harrison. Presidential elections have always loomed largest in our politics. But in a way, they now loom larger than ever. Every 4 years, we elect a president, and I don't think it's an exaggeration to say that our presidential elections feel like the everything election. The everything election. Every major public issue seems to get wrapped up in them. Even some local issues. I come from, in Virginia, I live in Loudoun County. You may have heard of our schools on Fox News. Loudoun County has been sort of the center of the East Coast, or at least Northeast corridor political debates over school policies. And my guess is by the time this presidential election is done, you'll have national presidential candidates talking about local schools and local school policy. Somehow they tend to sweep everything up. And not accidentally, presidents, they staff administrations, which make policies, which are the central driving force of our modern national government. Congress, the first branch, it says it right there in the Constitution, right? Article 1 of the Constitution is about Congress. Congress is still very important. I see them on TV all the time. But when it comes to policy making, the central engine of American policy making is in administrative agencies and in presidencies, which is why the elections have a feel of being about everything. There's almost a feel among the political parties that each election is almost a kind of regime change, where the party that's out of power, and by the way, we always say a party is in power or out of power, and we're always referring to their relationship to the presidency, right? Is there a person in the White House or not? The party that's out of power is hoping to displace the incumbent president so that they can sweep in and change everything up. And so in the run-up to this presidential election, I promise you there will be huge teams of people in Washington, D.C. working behind the scenes, especially for the party that's out of power, drafting executive orders and regulations and guidance documents so that if a new president comes to office on day one, there will be a whole new set of executive orders. Half of them are just going to eliminate the last president's executive orders, followed by a burst of energy in administrative agencies. And that's usually the first 100 days, the first 6 months, the first 18 months. And then those agencies will start putting out their policies, and everything will kind of grind to a halt. Because that's when the lawyers get involved. We're always fun. I practiced law for a dozen years. I still consider myself a recovering lawyer. Every day is a struggle. But the lawyers come in, the other team of lawyers, and they try to stop all of these agency actions in court. So you have this run-up to the election, everybody debating everything. The president's elected, he claims a mandate, full of energy, lots of excitement, and then it all kind of grinds to a halt. Are there English majors in the room? That would amaze me, actually. But I always wonder, what's the better metaphor? Is this T.S. Eliot's, this is how the world ends, not with a bang but a whimper? Maybe it's Macbeth. This is a tale told by an idiot, full of sound and fury, signifying nothing. That's the best way to describe like the 18th month of any presidential administration. Right around then, when everything kind of grinds to a halt, and then, what do? We start waiting for the next presidential election. Along the way, you have Congress doing a few things. I'll talk about that. The courts obviously get involved. But the modern government is one in which the presidential election is a big bang of activity that slowly fizzles out. And even though we spend every presidential election arguing about everything, by and large, no single presidency changes all that much in day-to-day life. They give us new things to argue about, but whether it's the laws that Congress enacts and the president signs, or the regulations that an agency puts out, doesn't change that much because the next administration is going to change those regulations anyway, and they all get stopped, half of them get stopped in court anyway. And so you reach the point where the Supreme Court becomes the center of the action. And that's basically where we are right now, halfway through the Biden administration. We saw President Biden in the last year of the Supreme Court's work. His EPA's climate policy was challenged in the Supreme Court. His policy in enforcing the Clean Water Act over what we call wetlands, that was challenged in court. The student loan case, of course, and on and on. It's very, very strange for somebody like me who's been working on administrative law for the last 20 years to suddenly find administrative agency cases really being the center of every Supreme Court. Sure, there are other cases, of course. This year, the affirmative action cases were probably the biggest deal in the Supreme Court. But more and more, we're getting more and more cases about administrative agencies. All the cases during the COVID pandemic, where it was a collision of religious liberty and the executive orders that governors put out in their states, the CDC eviction moratorium, the OSHA vaccine mandate. This is sort of the core of the Supreme Court's work right now. And it's even more than that, because when you look at the constitutional cases the court takes, they're often argued with administration in the background. Here's an example. Anybody heard of a case out of New York called Bruin? It was what was it about, sir?
It was about New York's may issue licensing for handguns.
Exactly. New York's licensing framework for the permission to carry a handgun. It was mostly about the Second Amendment, the right to keep and bear arms. But when you read the Supreme Court's decision, so much of their analysis hinges on the amount of discretion that the licensors in New York had to grant or deny these permits. Same with cases about, say, religious liberty. There was a big case a few years ago called Masterpiece Cake Shop. It came out of Colorado. It was a collision between religious liberty and the right to same-sex marriage as enforced in the state of Colorado. And although the case was mainly about religious liberty, the Supreme Court, its entire analysis hinges on the actions that certain Colorado regulators took, the things they said along the way. Were they discriminating against religion? It was a case about religious liberty and about same-sex marriage and about administration. So over and over again, the court is coming back to these themes about how much discretion agencies have and how it shapes day-to-day governance and day-to-day life. The Roberts Court seems particularly worried about agency discretion. And I'm not just talking about the conservative justices. During the Trump administration, some of the most significant cases had to do with immigration policy. Remember, President Trump tried to roll back President Obama's immigration policy, DACA, and the Supreme Court stopped President Trump from doing it. They said that his agency had changed the policy without giving a sufficient explanation of why. When President Trump's administration added a citizenship question to the census through the Department of Commerce, that gets blocked in court. They didn't say the president and his administration couldn't add that question. They said that the agency had abused its discretion by not giving a sufficiently thorough and forthright justification for the policy. And those are really technical cases that I spend usually an entire semester putting students to sleep to, so I'm not going to delve into the details. The point is, whether it's a Republican in office or a Democrat in office, the Supreme Court for the last 10 years has worried more and more about agency discretion and the effect that it has on day-to-day life, on the decisions of not just individuals and families, but on businesses that might be trying to plan for the future. The first stage of my career, I worked on energy infrastructure. I was like a pipeline lawyer. and trying to raise capital for a huge infrastructure project where nobody knows what the rules will be 4 years from now, 8 years from now. It deters economic innovation, economic growth. The tech companies right now are worried oftentimes about, are they going to get too much regulation, not enough regulation, the wrong kinds of regulation. The only thing they know, and not just on AI, but on any number of other things, the social media companies, for example, they don't really know what the rules are going to be 4 years from now. And so often that results in people taking a kind of a defensive crouch. And the Roberts Court has been drawn more and more to those concerns. And that brings me to the core, my main point today, that these concerns about, today we call it regulatory uncertainty, regulatory flip-flops, the way the laws change from one administration to the next, that's not a new problem. At least it's not a new worry. And in fact, it was among the central worries of the founding generation. It's Constitution Day, or not yet, it's almost Constitution Day, Constitution Day Eve. Are we there yet? Is it coming? I should know this. I should have gotten you all gifts. When Hamilton and Madison are writing in defense of the Constitution, they cover a lot of ground. But one of the least appreciated parts of the argument for the Constitution was about the kind of administration it would create and the kind of administration we need for a flourishing life in America. And I don't mean that in a partisan way. I don't mean you need a Republican administration or a Democratic administration. I'm talking about the style of government. There are no English majors in the room. Are there any political science people in the room? Anybody read the Federalist Papers or some of the Federalist Papers? You had your hand up earlier too. What's something you learned from the Federalist Papers?
I guess just the importance of having a government and the structure that it provides, but also knowing that you can't possibly cover every specific detail within the confines of something that has to be progressively figured out.
That's something we talked about in our class, that last part. That's a great point. The importance of structure and the structure of government to create a framework for sorting things out. Bridget, anything else from the Federalists that comes to mind?
The best one is Federalist 37.
She knows. My favorite is Federalist 37, which is the one that makes the point that you just made. When students learn about when they read the Federalists in their political science classes, they almost always cover a few of the greatest hits. Federalist 10 is about federalism. Federalist 51 and the ones around it are about checks and balances. Federalist 70 is the president. You need an energetic executive. Federalist 78 is on the courts. I like Federalist 37. I always call it the flyover country of the Federalist. I'm from Iowa, so I'm allowed to make that joke. But it's one that gets skipped about this process of sorting things out over time. And the Federalists that I want to focus on today, and I'm not going to get pedantic about it, but the ones I'm going to refer to very generally, you're going to find from Federalist 68 to 76. 68 is where Alexander Hamilton introduces the need for an electoral college to pick the president, all the way through to Federalist 76, which is about why you need the Senate to have a role in approving or disapproving the president's cabinet. In there, Federalist 70 is the famous one. It's about energy in the executive. Just a few years after we throw off the shackles of monarchy in the Revolutionary War, Hamilton and Madison, Washington and others are making the case for a strong executive, and a hugely contrarian case at the time. In the founding era, the critics of the Constitution were worried about national power and they were worried about executive power more than anything else. And in the case for executive power, Hamilton writes, we need energy in the executive, not just to defend us from attack, from war, but also for what he calls the steady administration of the laws. And what follows in the Federalist 71 to 76 is all about those two words, steady administration. Because fans of presidential power, they love to focus on energy. They want their president to get elected with a lot of political wind in his sails, a lot of political capital to spend, somebody who can get the job done. And that's why you get that flurry of activity, the executive orders and everything else. But that is not Hamilton's point. Or at least that's not the whole point. Yes, you need energy, but you need it for the steady administration of the laws. He was worried more than anything about what he called feeble execution. The idea that the president would not actually be able to enforce the laws, so people wouldn't take laws seriously. Right? He said feeble execution is bad execution. Bad execution is just another word for bad government. And in the papers that follow, everything about the presidency comes back to the need for energetic but steady administration. Why do you need a 4-year term? You need a 4-year term because the president is going to need some time to actually complete the big projects that Congress has tasked him with. And he's going to need to have time to go back to the people and make a case for why what they're doing is good and why it needs to continue. That's the reason why it's not just a 4-year term, but the possibility of re-election. Because the founders knew that the president might need more than 4 years to get the job done. And in that argument for re-election, Hamilton introduces another term. He says there's a great danger in mutable administration. Mutable administration. The metaphor I use for that, which might be lost on the younger people in the room, is that mutable administration is kind of like an Etch-a-Sketch. Anybody ever use an Etch-a-Sketch? You know, you draw on it for a little while, you put it down, your kid's sister comes in and she takes it and shakes it up and it's clear and you start all over. It's great for a toy, terrible way to run a country. And even in the founding era, this is what Hamilton was worried about more than anything, was that the more often we would change presidents, the more often new presidents would change everything. He says at one point in the Federalist, new presidents will change what's already there just for the sake of changing it, because his predecessor did it, not him, and he wants to prove that his way is better. So changeover, whether it's every year if they hadn't had a 4-year term, whether it was every 4 years if they couldn't run for re-election, whatever, Hamilton was very worried that a change in leadership would upend everything. Now, of course, part of our system is a change in leadership, right? We elect these presidents and we can throw them out. Congress can change laws. In fact, Congress should be changing laws over time, right? They shouldn't just be written once and for all. That's basically what you have a constitution for. Legislation should be amended over time and reformed, and of course that's going to cause change. But for Hamilton especially, stability is crucial. In Federalist 49, I'll promise I'll stop throwing out Federalist numbers like bingo cards in a second, but in Federalist 49 earlier, Madison writes about the need for stability in our constitutional system. Right? Jefferson thought maybe all laws should change every 20 years or so. We ought to have a lot of constitutional conventions, make it easy to change the Constitution. Madison says, no. You want some change. Change can be good, but you can have too much of a good thing. And you want to have enough stability that the people come to respect their government. Madison even describes it in terms of reverence. We want to foster a sense of reverence for our Constitution. Not blind faith, right, but sort of well-earned reverence over time. When Hamilton is writing about steady administration, he's making a very, very similar point. His point is that good administration that's stable, that allows people to plan their lives without having to worry about a constant change in laws, that's a much more flourishing country, a much more stable country, and it's a country in which people will actually come to respect their government. Again, think about present times. You know, you look at the approval ratings for different parts of government, Congress, the president, now the Supreme Court. Virtually every constitutional institution's approval numbers are at an all-time low. There's a lot of reasons for that. But I think one of the reasons why people's respect for government is so low is that they don't really give us time. We don't have, what's the right way to put it? Nothing sticks around long enough to be respected. Right? That everything changes. Like I said, we spend all this time arguing around presidential elections. We all kind of know that even the newly elected president isn't going to be able to actually do everything he or she promises to do. So we become a little bit cynical, maybe a lot cynical about this. I don't think it's an exaggeration to say we're basically living in Hamilton's nightmare right now because we don't respect government. We don't respect government because government is so unsteady. And government is so unsteady because we've organized our politics for constant change rather than a process of legislating laws that get administered and actually settle things. Again, I don't want to overstate it. We have change in our system for good reasons, but like I said, you can have too much of a good thing. So what kind of government are we left with today? Think about this. The president and his administration is now the central lawmaking body in our government. In a way, the agencies are doing the kind of thing that we expected Congress to do in the first instance. What's Congress doing in the meantime? How does Congress spend most of its time? You know, Madison writes that ambition is going to counteract ambition in government. And somebody, one of my colleagues at AEI once said, you know, Madison was wrong, we don't have that anymore. And then another one of my colleagues said, no, it worked out exactly the way Madison planned. Some people's ambition to get on Fox and Friends counteracts other people's ambition to get on Morning Joe. So members of Congress spend a lot of time on TV, and when they're actually in Congress doing the work of Congress, they're mostly having oversight hearings. Anybody ever watch an oversight hearing on TV? You have better things to do, Clemson football games. If you ever turn on C-SPAN and you watch a congressional hearing, you get rows of chairs where members of Congress, they're all seated looking forward. They're not in the House or in the Senate looking at each other talking. They're almost seated like a Supreme Court. They have witnesses. The members of Congress are kind of casting judgment on things that have happened. You're right, you're wrong. The president's right, the president's wrong. The Congress kind of acts like the Supreme Court of public opinion in a way. And what are the courts doing along the way? Again, this is what I teach in administrative law. I won't bore you with it. But more and more, the courts are no longer in the position of saying, here's what the law means. They're asked, what's reasonable, right? Was this emergency policy reasonable? Was the president's explanation for this reasonable? Is the agency's reading of the law reasonable? All sorts of prudential judgments that look more and more like what you'd expect a president to do, sort of prudential judgments. It's almost like a weird game of musical chairs. Everybody's moved over one seat. President's acting like Congress. Congress is acting like the court. District judges and the courts are kind of acting like the president, second-guessing presidential judgments. It's all because we've allowed administrative agencies to become the center of gravity in our policymaking. So what comes next from the Roberts Court? If there's any legal beagles that follow these things, happy to talk about specific cases, but just in broad strokes, here's what the court's about to decide. For about the last 30, 40 years, the Supreme Court has told the lower courts, give a lot of deference to how agencies interpret laws. The laws that Congress has written for the last 100 years are usually written very broadly. And so when a new administration comes in, they pick how they're going to interpret the laws. And the Supreme Court has said, let's just defer. As long as the agency is being reasonable, we'll allow the agency's interpretation to prevail. The court's now rethinking that. Justice Thomas and Justice Gorsuch are probably the leaders on this. Also Chief Justice Roberts in surprising ways I could explain in detail. They are more and more worried about the courts being too deferential to the agencies. John Marshall said famously in Marbury versus Madison, Chief Justice Marshall, he writes for the court that it's the duty and province of the courts to say what the law is, what it means. And Thomas and Gorsuch especially are saying, the courts have abdicated that role. We need to stop deferring to agencies and read the law for ourselves, which, as Bridget and I and our classmates this summer discussed at length, that's often easier said than done. But Gorsuch and Thomas are trying to move the court in that direction. Second, there are major cases involving agencies like the Securities and Exchange Commission. There's a case called Jarkisi, or Jarkisi. The lawyers all know how to pronounce it in about 2 months after it's argued. But there, the case goes to what are the basic powers that an agency should have when it goes about enforcing the law? And how do you limit the agency's discretion in deciding where to prosecute somebody or who to prosecute? And then finally, the big case that's on the docket involves the Consumer Financial Protection Bureau. This agency was created about 10 years ago. It was given immense independence. Independence from the president, which the Supreme Court struck down a few years ago, and also independence from Congress, which is the issue now. The CFPB doesn't actually have to go to Congress to get funding. they're entitled to up to 12% of the Federal Reserve's operating budget every year. It's a pretty sweet deal. They send a letter to the Fed chairman. The head of the CFPB says, it's that time of year, we'd like our $600 million now. And the Fed is obligated to say, you betcha, here you go, we'll deposit it in your account. Please contact us with any concerns or questions. So the agency doesn't have to go to Congress to get its funding. Enormous independence. That was the point for people who wanted to protect the CFPB from influence in politics. But now the Supreme Court will decide whether that is too much independent power and discretion, the discretion of an agency to pick its own budget. Over and over again, the court is going to return to these themes. It's impossible to avoid them, especially as agencies either receive more power from Congress or claim more power from Congress. It's no exaggeration to say for the next 25 years, this is going to be the central fight in the Supreme Court. For the last 25 years, it was primarily fights over what the court called substantive due process, the right to privacy, right to contraception, the right to abortion, and I don't mean to give short shrift to those issues. I'm just saying those issues were the predominant issues that for 25 years were the center of the Supreme Court universe. Everything else sort of revolved around those issues, and they'll continue to be important. But now the administrative issues are in the center, and the best evidence of that is what's the first big post-Dobbs abortion case that's going through the courts? When the Supreme Court said we're overturning Roe v. Wade, we're returning this issue to the states, I joked on the AEI podcast, well, yeah, it'll go back to the states and first and foremost the administrative state, because abortion will now be fought out, the right to abortion will be fought out in administrative agencies. And so the FDA's approval years ago of the drug that's commonly referred to as the abortion pill, that now is the subject of litigation over whether the agency was right or wrong in approving that drug. Over and over again, those cases are going to be administrative cases. And so years ago, when Justice Scalia, the late Justice Scalia, who started his career as an administrative lawyer, at one point he was a lowly AEI think tank staffer, he said once in an early lecture, administrative law is pretty sleepy stuff, so please hold on tight to the sides of your seats, try not to fall asleep and fall out of your chair, and he said, I'll try not to put you to sleep. Now more than ever, you're going to find yourself hearing about these cases. And so take them seriously, and when in doubt, call your local administrative law professor. We're here to help. Thanks again for letting me come. I'm happy to talk about anything. And one last thing, as was mentioned, as I sit here, often criticizing the Biden administration on policy. I am a Biden appointee myself. He appointed me to his commission on the Supreme Court about 3 years ago, where we studied issues about what's commonly called, what I call, court packing and other things about the Supreme Court. So I'm happy to talk about that and the politics around the Supreme Court too, or anything else you'd like to discuss. Kate? At some point I'll get used to the back and forth with the microphones. Can you hear me now? Does this work? Can you hear me on the camera? Okay, great. Any questions? Have I put everybody to sleep? Yes, sir. The microphone will find you. Just 1 second.
Talk about the delegation clause
Yeah. In the Constitution?
The Constitution with respect to Congress not writing laws that are clear,
Yeah.
we're delegating too much to the administrative state.
You got it. I'll repeat the question. He asks, can I talk about the delegation clause, the problem of Congress not writing clear laws and granting the administrative agencies broad powers? It's a trick question because there isn't technically a non-delegation or a delegation clause, but it is a basic principle of the Constitution, right? In Article 1 of the Constitution begins, all legislative powers herein granted shall be vested in a Congress. And then Article 2 is the executive power shall be vested in a president. Congress doesn't actually say we hereby transfer our legislative powers to this agency or that agency. But in effect, that's what people often say is happening. When Congress writes a law that says, for example, again, former pipeline lawyer, FERC, the Federal Energy Regulatory Commission, shall approve natural gas pipelines that are in the public interest. Or the Federal Trade Commission should ban any competitive practices that are unfair or deceptive or abusive. Very, very broad terms, hard to pin down exactly what they mean. And so for a long time, the Supreme Court has said that if Congress doesn't give the agency any kind of intelligible principle to actually limit the agency's discretion, that is an unconstitutional delegation of Congress's legislative power. Now, this has been talked about for a long time, all the way back to Chief Justice Marshall in the very early decades of the Supreme Court. But only twice has the Supreme Court ever struck down a statute for delegating legislative power to a government body. As one law professor once said, this non-delegation doctrine has had one good year, the year 1935 when those two statutes were struck down. It's had one good year and 200 bad years because this doctrine never gets enforced. Now, in the last few years, the same worries about administrative agencies have led the justices, a number of the justices, at this point probably 5 justices, to say we need to tighten this up. We need to strike down more statutes that delegate open-ended power to agencies. There is a great risk in this. Justice Scalia himself, back in his old AEI days, he worried that even though we can understand this basic principle, Congress shouldn't delegate away its powers, there isn't a clear rule in the Constitution explaining where you draw that line. What's a law that's so open-ended that it's unconstitutional versus a law that's pretty open-ended but not unconstitutional? And so Scalia said, tread very, very lightly here before you start striking down laws on this ground. Justice Thomas, Gorsuch, Roberts, Alito, and Kavanaugh have all expressed interest in the last 10 years over becoming more energetic, we'll say, in striking down these statutes. One of the big themes of this moment is that everything I'm talking about, the justices tightening up on agencies, is a huge reversal, not just in Supreme Court precedents, but reversal of Supreme Court precedents that conservative justices wrote in the first place. In a lot of these doctrines about deference to agencies, they arose in the 1970s to the 1980s when there was a lot of complaints that judges were micromanaging the Nixon, Ford, and Reagan administrations. Those administrations would say, we're going to loosen up some regulations. In the early 80s, one of the big issues was the seatbelt rules back when those were brand new. And the federal court in D.C. would say, no, you need to regulate more. Scalia, Rehnquist, others, they thought that was micromanagement by the courts. They said, you got to ease up. So what we're seeing now with this tightening on the agencies is not just a rethinking of precedents, it's a rethinking of basically conservative precedents. The big case about deferring to agencies, it's called Chevron deference, Chevron the oil company. Chevron was challenging an EPA policy. Have you ever heard of this case, sir, the Chevron case? Do you happen to remember who was running the EPA when Chevron was decided? Her name was Ann Gorsuch. You want to guess who her kid is? It was Justice Gorsuch's mother when she ran the EPA. So we've seen a fundamental change in the conservative approach to administrative law. And I'll tell you, and then I promise I'll shut up and take another question, but I'll tell you there is real risk in the court moving too fast or too far on these things. Even Scalia, near the end of his life, was saying in some speeches and hinting, I think, in some judicial opinions, that he wanted to recalibrate his own approach, maybe be a little bit less deferential to agencies than he had been. He was seeing that the costs of that approach were maybe higher than he thought, the benefits were lower than he thought. He wanted to recalibrate. But he wasn't totally wrong, not at all. And so I think conservatives now who are cheering on Thomas and Gorsuch and others and saying, yeah, we need to tighten up on the agencies, they all, and I trust they all are, going back and taking seriously what Scalia and others were saying in the 80s. We don't want a country in which the courts are micromanaging everything, right? Their job is to say what the law is, not to be policymakers. It's very hard to draw that line sometimes, and that's why the court struggles with this. But to your point, and to your point when mentioning Federalist 37, Madison writes in Federalist 37 about how we're always going to have some vagueness in laws. It's impossible to write laws perfectly clearly. No matter how much skill and time is spent on writing a law, sometimes they're going to be a little vague, sometimes they're going to be a lot vague. But the answer for Madison isn't for the judges to kind of swoop in and decide everything right away. He says the meaning of these vague laws needs to be liquidated over time. That was his word, liquidated. We're going to make it clearer. We're going to bring the law together through a series of decisions in court, out of court. Administration has to be the core part of that process where you take vague laws and you bring it into certainty. And then the courts at the end are going to rule, but the agency's job should be funneling from, if I had my hands free, I'd say, from uncertainty over time down to certainty. And that requires a few qualities that you don't see in administration anymore. It's a basic mindset of restraint and duty. The president has a constitutional duty to take care that the laws are faithfully executed. He swears an oath to faithfully execute his office. It's a mindset of duty and responsibility, not just power and ambition, and certainly not just discretion. The founders knew that presidents would have power and ambition and discretion, but they also needed a lot of duty. And to bring it back to your original question from about 25 minutes ago, that's the big problem with delegation, is that if we don't start the process with Congress at least trying to be clearer, they'll never be perfectly clear, but at least trying to be clearer, then you make the president's job even harder, and you make the court's job even harder. And that's what the Supreme Court is grappling with now. Any other questions? Here, and then maybe we'll follow down to the second row here.
Hi, I'm Will Lawson. I'm a junior here in the Lyceum program. Thank you so much for taking the time to talk to us. The point about living in Hamilton's nightmare really resonates with me as being someone who's cynical about the government, for better or worse. But I understand I might be skirting the role of the courts when I ask this question. But when I think about combating these administrative agencies, they seem to arise from what I think would be two sources of a weak Congress and weak state governments. So I was wondering if you could expand more. You kind of hit on it when you were talking about now what's happening with the abortion debates being pushed to the states, but not really, because it's just going to the FDA. But I don't know how explicitly I want to ask this, but in the sense of maybe what's more important, or what do you think?
And everybody in the room and whoever ends up watching the video.
What could change? What could change? What do you think would be able to change the quickest or the most effectively? Whether it's within this, giving the states more power, or having a Congress that actually does more, so it's not just up to the courts to determine what's reasonable. How do you see that playing out if we're going to be a little bit more optimistic?
Sure, and that's a great question and a hard question. So hold on a second. Let me just cheat and say, do you want to venture a guess? Can you have the microphone back, please? Do you want to venture a guess why we have a weak Congress and weak states? I'm sure there's a lot of answers. I'm just curious if you want to take a stab at it.
Well, I mean, I think you kind of pointed to in the beginning of your talk that we have a tendency to just look towards this big federal government, or explicitly to the executive. When we think of elections that matter, we really only as citizens think about the presidency. And so maybe a tendency just towards that power being consolidated on our own end. And then also, now we're just living in the consequences of these administrative agencies just being left on track.
Great ideas and a hard question, and there's a lot of answers. Part of it surely is political parties, right? That whether it's in Congress or in the states, let me put it this way. When Madison was writing in defense of the Constitution, he wrote about the institutions, and he said members of Congress, they will think as members of Congress, and a president will be a president, the courts will be the courts. Ambition will counteract ambition, and as he says, the rights of the man will be attached, the interests of the man will be attached to the rights of the place. A member of Congress will be first and foremost a member of Congress. Well, it didn't work out. Because as early as Martin Van Buren, you really had a real theory of political parties. And the political parties were created to solve real problems of organization. The Electoral College wasn't serving quite the purpose it was intended to. But for whatever reason, the political parties became the common thread. And so in a way, you have a weak Congress because half the members of Congress define themselves as the president's people in Congress, and the other half of Congress thinks of themselves as the president's opponents in Congress. And yeah, you have now 50 states, and the idea would have been that they'd be the laboratories of democracy, right? 50 flourishing experiments in democracy, but what you really have are a group of red states and a group of blue states, and there's sort of two ways of governing, more or less. And of course, even at the state level, governors, other elected officials, they think of themselves largely in relationship to the national political parties, the national party's agenda, and the president. That's one issue. Another issue is just technology in a couple of ways. Congress has delegated more power to agencies. States have ceded more authority to the federal government because a lot of the issues that are now being dealt with through legislation, they're seen as too complicated for Congress to really deal with, too complicated for states to deal with. So the states cede more power to the government, the federal government, and the Congress cedes more power to administrative agencies. And also, relatedly, technology has accelerated the pace at which we tend to think and debate these things. And not just on social media, right? But the greatest challenge to James Madison's theory of Federalist 10, right? An extended republic where things would filter up through the states and we'd have all kinds of debates over time. Well, that was basically undone by railroads and radio signals, right? Where suddenly people thought of themselves much more in terms of their relationship to the federal government because they could move around faster and they could communicate much faster. And so I think the pace of debating and policy making too has been affected by technology in a way that really favors administrators and presidents over the slower parts of government. Now, how do we get out of that problem? Just full disclosure, I'm the kind of Iowan who left the state, went to an East Coast law school, and then moved to Washington, D.C. and never looked back. So you're probably asking the wrong person about how to return power to the states. And the states aren't a panacea for reasons that James Madison said and wrote. But I'd say part of the way out is going to be what the Roberts Court has been trying to do in limiting agencies. It's been returning some power to the states. The big fight over the Clean Water Act, the Clean Power Plan, those are both with an eye to federalism. But it's going to require members of Congress who actually defend their own local turf and their own local interests in their federal institution. That's the whole point of having, first and foremost, a Senate. But even for the House of Representatives, the idea was the members would have an attachment to their local districts. And we're not going to get back to that point unless voters actually demand it. And I don't know how we get to that point. So I think you asked me for an optimistic answer, and I just totally wrecked that, but it's an honest answer. Yes, ma'am.
I'm Elise Bloom, and I'm also a junior here. I was wondering, kind of along similar lines, if agencies in the executive are kind of the driving force of this unstable administrative state where change is constantly, people are willing to affect change, do either agencies or the executive have any incentive to want to change that? I see a small amount of incentive in the executive for wanting the office to be esteemed, but I can also see how that would work against the solution because they therefore want to accomplish a lot.
Yeah, it's hard to see the reforms coming from the agencies and the presidents themselves, right? The whole premise of our system was that each branch would jealously guard its own powers and push back. And if anything, the worry was that Congress would be the one I think at one point Madison calls Congress an impetuous vortex that'll draw all power to itself. Oh, those were the days. Now that's basically how we tend to think of administration. And I'll tell you, you often hear presidents cite the weak Congress as justifying further presidential action. President Obama famously said, if Congress won't act, I will. He had the best, punchiest version of the line, but it's the basic theme of modern administration. When President Trump wanted money for his border wall and Congress wasn't giving it to him, he said, well, I'll reallocate more money from defense over to the border wall project, from other defense projects to the border wall. He said, and frankly, members of Congress cheered him on. In the same way the members of Congress cheered President Biden on the student loan programs or on on climate policy and so on. Presidents say, if Congress won't act, I will, but it's because presidents can and will act that Congress doesn't. Like, imagine you're a Republican in Congress right now. Democratic president, you're a Republican in Congress. Say there's an issue you care about, climate policy, whatever your position on climate policy is. Getting it through Congress is going to require real compromise. If you're a Republican in Congress, are you going to sort of meet the president halfway on a compromise, knowing that if you do, you'll probably get primaried for it? And the fact is, the president doesn't need your compromise because the EPA will probably try to make the policy he wants. If you're a Democrat in Congress with President Biden in office, and you care about climate policy, are you going to propose some compromise that might win over Republican votes? No, because you'll get primaried too. So Congress stands still, hoping and knowing that presidents will lead the way in policy. The only way out of it is really Congress reclaiming its power, the courts nudging Congress back into action, but all of the hydraulic forces in our political system are pushing towards more presidential power, not less. Time for a couple, what time? Time for a couple more. Maybe right here, and then the next one will be in the back.
Hi, I'm Dylan Miller. I'm a senior here at Clemson. And you spoke a bit about how, kind of like a game of musical chairs, everyone has shifted seats in terms of what their roles are. And one of the things that's been ceded to the Supreme Court is, in some ways, to be the executive, to determine what the policy goals and initiatives are of the country and to decide like what's best for it.
Yeah.
But isn't part of that not just that the power's been ceded to them, but that they've accepted it?
Yeah.
And I guess my question is like, in any case of where we think that the country is going to become a better place and we're going to care less about politics or whatever anybody's scheme is, doesn't the court stepping back, and what does that look like for you?
Yeah, that's another line from Shakespeare, right? Some men are born great, some have greatness thrust upon them. It's kind of the Supreme Court too. It wasn't created to be the central forum of policy debates, but it often has those debates thrust upon it in a couple of ways. And I'd add one layer of complication to the question too. It's not just that the Supreme Court gets these cases, it's that as soon as Congress or a state legislature or a governor or an agency or the president makes a policy, what happens? Immediately there's a lawsuit filed. If there's any law students in the room, they know that in the last 100 years, Congress has created more and more ways for people to sue to challenge a law as soon as it's written. And if you're somebody whose constitutional rights are at stake, you're glad that you can go to court right away, right? That's no small thing. But the fact that now as soon as any policy is written, you immediately have a lawsuit before a federal trial judge, probably a judge whose court has been picked by the plaintiffs as having the best shot at ruling in your favor. Back when I was in legal practice, you'd sit there and you'd write memos saying, should we file this lawsuit in Texas or in Colorado or where we have the best chances of success. That's why right now, basically every suit against the Biden administration gets filed in the federal courts in Texas. During Trump, everything was filed basically in San Francisco, Seattle. And trial judges, and they're not, sometimes people say Obama judges, Trump judges. I hate that. All these judges, whether I agree with them or not, they think they're doing the right thing, but they read the law differently. And so a case goes to a judge in Texas, and he very quickly rules against the Biden administration, and he issues an order saying the Biden administration is banned from enforcing this new policy nationwide, not just in my district, but nationwide. And that's one of the things that brings everything quickly to the Supreme Court, because as soon as a federal trial judge issues a nationwide order, then the Court of Appeals is going to get involved very quickly, and probably the Supreme Court. And so the problem is not just that the Supreme Court is hearing more and more of these issues, it's that the Supreme Court is receiving these cases faster and faster than ever. It's one of the big issues that we were studying on President Biden's court commission. The court has tried to slow that pace down in good ways so far. Chief Justice Roberts was the most hesitant, the most vocally hesitant about the court intervening too quickly. Especially during the COVID orders, Justices Alito and Thomas and others that I respect, they really bristled at the slow response of the Supreme Court, and for good reasons. But Roberts had good reasons, and the other justices had good reasons for wanting to be slow too. And I think that's really crucial. The court needs to slow down its pace of intervention. And like you said, the Supreme Court needs to get out of the policy-making business, or at least minimize that. Years ago, Justice Scalia, in one of the big abortion cases, right when Supreme Court nominations were becoming really heated stuff, Robert Bork, Clarence Thomas, David Souter, Scalia writes a dissent, and he says, as long as the Supreme Court is designating itself to be the nation's policy-making body on abortion, the more that Supreme Court nominations are going to become knockdown, drag-out fights. Because, he said, the American people love democracy and they're not stupid. And if they think the Supreme Court is making all the political decisions, they're going to make their voices heard too. Now, at this moment, a lot of people would say the same of the Roberts Court. And I disagree with them on a lot of those things, but it's an important thing to keep in mind that the more that the court is either dragged into fights over policy or jumps into fights over policy, the more careful it's going to have to be to show that what it's doing is really judge work, not policymaker work. That their decisions are based on the rule of law, that their discretion is as narrow as possible when they're making difficult or controversial decisions. They're doing it out of a matter of duty rather than a matter of will, free will. And they still won't confuse it. They still won't convince everybody. They'll confuse people. They won't convince everybody, but they at least have to start and show that they're bound and acting out of a matter of duty. That was a great question. Next, sir. And maybe this will be the last one. Thank you.
Hi, Simon Dunn, senior year. I wanted to ask, you talked about how there were some shifts in the 70s and 80s. You talked about how branches have been bleeding into each other in terms of their power. But you also mentioned that 20 years ago, you never saw things of administrative law at the Supreme Court level, but 10 years ago, that was beginning to be the main focus.
Yeah.
I want to know what precisely was the shift 10 years ago?
Yeah.
What exactly happened that caused that new game to start being played?
Yeah.
And then sort of the second part of the question is, what would be the incentives? What needs to happen to convince Congress to be Congress, to convince the Supreme Court to be the Supreme Court, to convince the President to be the President?
Yeah. Yeah, and I'm prone to overstatement, so I should qualify it. It's not as though the court was never hearing cases about agencies. Like famously in the New Deal, right? That was a lot of agency cases. In the late 1800s, huge fights over the regulation of railroads at the time. And so there's always been agency cases. But I'd say it's hard to remember a time other than maybe that there's a day called Black Monday where the Supreme Court decided 3 really important New Deal cases. It's hard to think of a 10-year era where administrative agencies, administrative law was so central to the court's docket than it is right now. What's changed in the last 10 years? I'd say it's 2 things. One, in the second term of the Obama administration, when President Obama lost Congress and he said, I have a pen and a phone and I'm going to use it, his agencies proceeded to make policy on some of the most consequential policy issues of our time. Net neutrality, the internet, climate, environmental regulations, financial regulations. Their agencies had a confidence and ambition, and also I'd say a level of innovation and creativity that really left, say, the Clinton administration in the dust. If this was just a matter of Republican-appointed judges not liking Democratic presidents, all this would have changed in the 90s when Clinton was president. It wasn't the case. It's that in the second term of President Obama, agencies became more creative, more ambitious, and faster moving than ever before. Things, again, like the immigration policy and so on. At the same time, in that moment, you had a few legal scholars who were really calling for the courts to assert themselves more against especially the agencies, but also against other policy-making bodies. Professor Randy Barnett, one of my teachers in law school, he's now at Georgetown. He's written a number of really challenging books on judicial power and judicial responsibility. Philip Hamburger wrote another great law professor at Columbia Law School, wrote a few books on this, culminating with a big treatise called Is Administrative Law Unlawful? It's a rhetorical question. His answer was yes, totally unlawful. And he made an intellectual case for why the courts needed to push back against agencies. I don't agree entirely with those two. In fact, I've spent the last 20 years of my life sort of arguing among friends with both of them over how far they want the courts to go. But you had this change in the policymaking combined with a change in the intellectual zeitgeist among conservative law professors and a lot of the judges on the lower courts. And those two things together, I think, have combined to change the moment. I'll just say one last thing, since it's, again, almost Constitution Day. In that little patch of Federalist Papers I was referring to, there comes a moment when Hamilton is introducing the Electoral College in Federalist 68. And he begins by explaining how important administration is in government. Again, in the Federalist, he's writing about executive power, about judicial power. He covers everything, as you've seen in his famous Broadway musical. But he says in Federalist 68, the true test of a government is its tendency and aptitude to produce good administration. He likes that line so much that I repeat it all the time, but he even repeats it. In Federalist 76, eight papers later, he uses the exact same line, proving it's not just judges and professors who cite themselves, right? Hamilton says the true test of a government is the type of administration it produces. And it's fascinating when you think about it. It's not just a good test of constitutions or one of the tests of the constitutions. For him, it was the true test of the Constitution, is what's the character of administration that your Constitution is producing. Like I said, I think at this moment we're probably, as a country, failing Hamilton's test. It's a long path backwards. And as I said, the solution's not going to come exclusively from the courts. It's not going to come from Congress. It's not going to come exclusively from Congress. It's certainly not going to come from within administrations. It's going to be a combination of Congress and the states really being challenged by their own voters, and that's what's going to bring things back. So again, I'm grateful for the chance to come and meet you here today. I bet you're all grateful for the fact that they serve coffee after this, so maybe this is a great point at which to wrap up and we can make our way outside. Thanks again for letting me come.